I did not hit her. I did not hit her. I did not. Oh, hi, Mark. All right. Enough silliness. You're stepping out of the ordinary and entering the court gallery. What? No Chalky on Middleton Live? Are you kidding me? The horror! Ladies and gentlemen, whenever you watch Judge Middleton with Lone Wolf Usul and friends, Chalky is almost always active. Almost. But not always. Ladies and gentlemen, I do want to welcome you. This is the Weekend Review. I am your Lone Wolf Usul. I'm a little punch drunk because I've been putting this stuff together since last night. And I've been working all morning on it too. And it's a good set of cases. Ladies and gentlemen, we're going to pick things up in Texas with Judge Boyd, where she's got to deal with a simp. A guy who just really doesn't know how to say no to girls and gets himself in all the trouble in the world. Then we're going to go back to Judge Culotta in Michigan. No, Ohio. I'm sorry, we're all over the country today. Judge Culotta's got to deal with a thief who stole a prosthetic limb. We'll talk about that more. And then the next two cases, we have people wanting to fire their lawyers and accuse judges of being paid shills of corporate entities. And finally, we're going to end things on a dispute over a Hellcat that might not involve some sumo wrestling shenanigans. Ladies and gentlemen, I'm your Lone Wolf Usul. I'm your host for these here videos in this here compilation, and we're at the Weekend Review, and it all starts right now.
All right, who else is ready?
Roger Mims, page 6.
Roger Mims. Hello.
How you doing today?
Oh, I'm doing okay. I cannot complain. Currently alive. All right, I need the he said for sentencing.
Yes, ma'am.
Oh, I was not informed. I'm so sorry.
Okay, that's okay.
Who is this son again?
Roger Mims.
A copy of the.
I didn't get it.
All right, the court is calling 2024 CR 008-238B, State versus Roger Mims. Can I have parties announced for the record for the state?
James Tochi for Mr. Mims, Judge.
All right. You entered a plea bargaining agreement of no contest to counts 4 and counts 5. According to the plea, counts 4 and 5 are to run concurrently. Punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine, and the state is opposed to your application. For the state, all right. Have both parties had a chance to review the PSI report?
Yes, sir.
Yes, Judge.
Any objections?
No, ma'am.
State, do you have any witnesses?
No witnesses, just the evidence.
All right, defense, any witnesses?
Judge, I do. Mr. Mims is going to provide some information to the court this morning. I don't know if you wish to do it now.
You want to raise your right hand?
Just
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand, state your name for the record.
Mims.
All right, you may proceed, defense.
Thank you very much, Judge. Mr. Mims, the Judge Boyd obviously knows your name. Let's just give a little bit of background. Where are you from?
San Antonio, Texas, sir.
Okay. Are you born and raised?
Yes, sir.
Okay. Obviously, you know why you are here and what is going to be happening this morning before Judge Boyd.
Yes.
Tell Judge Boyd, we've already looked through the PSI. Tell Judge Boyd just kind of a little bit about you and your makeup and your upbringing, and then we'll slowly get into some of the things that you've had to deal with in your life. No, just about you. Where were you educated? How far did you get in school?
I graduated Southwest High School. After that, I went into Northwest Vista to do my basics basically for nursing, and I didn't get too far because I had problems with combined wave. I couldn't really pay for my books or anything like that, so I had put that to hold, and from there I just I guess I was distracted with not being in school or educated, or my mind wasn't really at the right. I've been through a lot of stuff, and just really couldn't really like get to where I wanted to be because of stupidity and just the way kind of I was living, and I take full responsibility for my actions and wherever I've led up to and how I led up to. So
Let me stop you real quick. How old are you, Roger?
I'm 30 years old, sir.
Did you graduate from this school?
Yes, sir, I did.
Did you ever go to college?
Yes, sir. Northwest Vista and Southern first. Sorry.
Did you ever finish or complete or receive any certifications or degrees?
No, I didn't get to.
Do you have children?
No, sir.
Now, in the PSI, it details some of the things in the past that are part of your criminal background. We've gone over those.
Yes, sir.
You have been on felony probation before, correct?
Yes, sir.
You were able to. I'm sure the state will ask you some questions about that. Let's kind of move a little bit into this area. So there is a co-defendant that's part of this case that has already been before Judge Boyd. Her name is Tiffany Vasquez, I believe. When did you meet her?
I hadn't met her from high school. I didn't really know her like that. Like 2023, yeah. I want to say like 2020 or 2023.
Describe the nature of your relationship with her.
It was not good at all. It was not good at all, to be honest. Always arguing, being lied to, it just weren't equal. We didn't make no sense to be together. We just couldn't coexist, Your Honor.
And tell the judge a little bit about, now, do you believe you have PTSD?
Yes.
Okay. Have you ever actually been diagnosed?
No, sir.
Okay. Why do you believe you have PTSD?
Just all my trauma, the trauma I've been through, just when I'm growing up, I've seen a lot of stuff, I've seen on the hands put on her. We'd have to run from, my dad. I've seen a lot of death in my family, some friends passing, and with that, it just brought a lot of. It was very hard for me to just walk a straight path, to be honest. There was really things in my mind I could never think straight. Like,
Were you exposed to violence when you were in your teen and
I want to say I was around people that were not good for me. To be honest, yes.
I'm going to show you a picture, Roger. I've already shared it with the prosecutors. Do you recognize that?
Yes, I see.
Okay. Judge, I would like for you to, I'd like to offer defendants one into evidence. I've already shared with the state. And I can share it with the court. What is Judge Boyd looking at in this picture, Roger?
Me on life support.
When was that?
2018, April 10th.
Okay. And how did that happen?
I was at a park and I got shot at AK.
Okay. Was a case filed on your behalf?
Yes, it was. I just didn't go over with the pressing charges.
Okay. Why is it?
Just being threatened. Threatening to keep the house up, and now it's my mom's house.
So the person that was charged with shooting you was indicted, but the case ultimately dismissed.
Yes.
And that is because you were being threatened.
Yes.
Does this kind of make up part of your mental makeup and what you believe to be your PTSD?
About 80%, yes, sir.
Let's get back to Tiffany and let's start kind of honing in on this particular evening. How long had it been since you had spoken to Tiffany before you got with her on this particular night?
About 6-7 months. No communication with her at all. I deleted her number, blocked her.
Were you aware that there was what is called a protective order that had been put in place for the two of you?
I want to say yes, but I never received any. I want to say yes.
Okay. You do recall receiving paperwork?
Yes.
Okay. But after that, did anyone follow up with you?
No, not at all. Not after that. No.
And had you seen Tiffany?
No, I haven't. Only on that date.
Why were you with her on this night?
She actually called me from a Text Me Now app and begged me to I could take a ride with her. Basically, try to talk her to her and stuff, but it led up to being a whole nother ball game. It was way out of what she told me it was going to be, and it led to that.
So you went with her.
Yes, sir.
That was a mistake.
Very.
Did you know where you were going or the purpose of her bringing you?
No, I didn't. She told me that it was her baby daddy's girlfriend or something like that. That if I could, she was gonna talk to her, and so I jumped in the car. I took my firearm on my behalf. I didn't know that was gonna happen. That's just something I normally do, is take my firearm everywhere I go. To be honest.
Were you asked to bring a firearm?
No, sir, I was not.
Okay.
She didn't know I had it until everything started happening.
Who is she?
Tiffany Martinez.
So what happened? Tell Judge Boyd, you guys are driving around. Were you following a car?
Yes. Following a car, got past Marbach, got past Ingram. We were going all the way. So but 3 stops, I told her we need to turn this car around. I think it's not a good idea. Like something's going to lead bad. So we kept going. She refused to turn the car around. She, please just go with me. Please just go with me. I said, okay. But then she said she would never talk to me again. She'll leave me alone. I went with her. We came to Thousand Oaks by the airport. We drove, and that's when everything happened, when we came to a stop in Henderson Pass somewhere.
Okay. So did Tiffany stop the car?
No, the girl was already out of the car, actually getting out.
Okay.
And she said she was going to have words with her. And
did you get out of the car?
No, I never got out of the car until the brawl started.
Right. And is that what happened?
Yes. Tiffany punched the girl a couple of times for no reason.
What did you do?
I told them to stop. I tried to break it up about 6 or 7 times before I discharged the firearm in the air.
Okay. Let's kind of slow a little down on the sequence. Did you get involved in, well, I'm going to call it a melee. Did you get involved in the melee?
Yeah, I separated them several times. I was in the, I even had a conversation with the girl trying to calm her down, like, hey, I'm so sorry this happened to me. Started up again.
So your involvement was to break it up?
Yeah, peacemaking,
okay.
Obviously.
Now, did you at any time strike
No,
the young lady?
Just only pulling them back. You know, of course, I was kind of aggressive, but I was pushing them back. You know, I couldn't handle two in one swing and then one swinging back. I couldn't handle that.
Was there a point in time when the two girls stopped fighting? You know, everybody has separated, and you guys are actually talking about what's going on.
Yes, me and the girl.
And I know that the judge has read the stipulations, but the reality is Tiffany went over there believing that that girl was involved with her boyfriend.
He was totally innocent.
Okay.
Yes,
But was that true?
that's what Tiffany was saying.
But was it true?
Yes, that she went to go.
Was it true that she was involved with Tiffany's boyfriend?
No, she was never. She didn't know who. She had no clue who Tiffany or I was.
Okay. Did you know that girl?
I never seen her in my life.
Did you have any reason to go over there and want to hurt her?
No, was not trying to harm none of them.
Did you have any reason to go over there, threaten her to take property?
No,
Okay. And did you actually do any of those?
no.
At some point, were you having a conversation with the girl about what was going on and
Yeah.
why you were there?
Yes.
Okay. And the reality is, Roger, were you mistaken yourself when you're having these conversations? Did you know that she hadn't been with Tiffany's boyfriend? Or did you assume that to be true?
I believed her from the start because she was very serious. I didn't. She showed her picture to Tiffany of who her dad or who she was dating was. She was very honest. I believed her 100%. Like she didn't have no clue who Tiffany or I was. She did not know us. She didn't know what was going on. She was very lost.
Did there come a point in time when the two girls started fighting again?
Yes.
And again, to be clear, that was the two girls. You were not fighting
No.
with the young lady.
No, at this point, I was standing by the car as they were brawling.
What did you do at that point?
So at this point, that's when belongings started getting taken, and stopped the fight. Obviously, gave the girl her purse back because obviously she snatched the purse and the phone. I was looking for the phone. I was looking for his girl's glasses, Tiffany's glasses. Obviously, trying to find everybody's stuff. As I'm looking for the glasses, they're in the street fighting again. You know what I mean? At this point, I got the purse. I put the purse right there on the screen. Tiffany grabbed the purse, threw it in the car. Phone, took it in the car. You know what I mean?
So at some point, there was a gun
Yes.
that was taken out.
Yes, my gun.
And what was the purpose of that?
I was scared him. I shot it and I told him I wanted him like, hey, I'm gonna shoot the gun in the air if y'all don't stop. That's exactly the words I said. And I let it off. I let the firearm go. They stopped fighting. And the girl took a picture of the license plate and Tiffany snatched the phone.
Did you take any of her property?
No.
Did her phone end up in the car you were
The
in?
phone was in Tiffany's lap.
Okay, and that's because Tiffany.
She took the phone.
Okay. Now that we're 2 years away from all that, we've talked about this kind of looking back on that situation. I mean, how do you feel about that girl in particular and what happened?
She didn't deserve it. She was innocent. I feel very bad for her to this day. I feel very bad. Like, just imagine somebody just running up on you, trying to get home. You know, you don't know who these people are. You can possibly get hurt. You don't know. Like, yes, I'm very sorry for what happened to her.
Okay.
She did not deserve it.
Now, you and I know from reading the police reports and watching what she told the police,
Yes.
you know that she told the police that she believes you were involved in part of the assault, right?
Yes.
Okay. Did you assault her?
No, I was only pulling her off of Tiffany.
Since that incident, obviously you haven't had been arrested for anything, correct?
Yes.
And then, Judge, I'd like for the court, or I'd like to offer defendants 1, 2, and 3 into evidence. If I may, I've already shared with the state. I don't believe they have objection to it.
The court will accept in the evidence defendants 1, 2, and 3.
Who are the children depicted in these pictures, Roger?
Some of my step boys.
Okay. Now you're not married, but you
No.
have a serious relationship.
Yes.
Is it a healthy relationship?
Very healthy.
Is she here in court today?
Yes, sir.
Where these young men in the picture, where's their father?
He's passed away.
Okay. So they kind of look to you as a father
Yes.
figure at this point.
They do. They didn't really get to know him like that. They didn't really get to know him.
Okay. And do you feel kind of like their father?
Yes, at this point, I'm 100%. I feel I take responsibility of 100% how they even grow up now. Yes, sir.
Now the judge has big decision to make. She can put you on probation. She can also send you to prison. If she were to allow you on probation, do you feel that you could do the things that you need to do to be successful?
100%.
Um, all right, Judge, for now, I believe that's all the questions I have, and I'll pass the witness to Ms. Calloway.
Yes.
Okay, Mr. Mims, so we kind of talk about the road that led you to where you are. Okay, and so if we look at that road, right, you were on juvenile deferred adjudication for about a year for one charge, is that correct?
Yes, ma'am.
And then in 2010, you were placed on juvenile probation for another charge, is that correct?
Yes, ma'am.
Okay. And then in 2013, you were placed on deferred adjudication for resisting arrest, and that was in 2014, correct?
Yes, ma'am.
Okay. And then in 2016, you're placed on felony deferred adjudication for attempted deadly conduct with a firearm. Is that correct?
Yes, ma'am.
Okay. And during that deferred adjudication, you did pick up a new charge, correct?
Yes,
Okay. And a motion to revoke your probation was filed, correct?
yes, ma'am.
And the judge decided to continue you.
Yes.
And then you picked up another MTR for testing positive for substances, correct?
Yes, ma'am.
Okay. And then ultimately the judge decided to continue you again, and then the case was dismissed for adjudication, correct?
Yes, ma'am.
Okay. And then in 2018, you're placed on for adjudication. And I guess it's running concurrently with the deadly firearm, but you're placed on deferred adjudication in 2018 while on deferred adjudication for deadly conduct. And in 2018, that new offense that you picked up was hindering apprehension of the felon. Is that correct?
Yes, ma'am.
All right. And then we have bill to ID from 2016 that you were placed on probation for in Comal County. Is that correct?
Yes, ma'am.
Okay. And then ultimately you were revoked and sentenced to 140 days in the Comal County jail.
Yes, ma'am.
All right. And then you had an assault bodily injury in 2016 as well in Comal County that they slid down to a lesser charge.
Yes,
Is that correct?
Yes, ma'am.
And so if we're talking about, I want to talk to you about Tiffany, because did y'all meet when y'all were in high school at Southwest High School?
I just knew who she was. We didn't never talk.
Okay.
We went to the same school. Like I
Okay.
knew who she was. She knew who I was. I was obviously athletic, so she knew I was one of the stars,
And so y'all just knew each other when you were at Southwest High School, but then later on y'all kind of.
Excuse me, just one moment. Mr. Porter, could you review that state has and with Mr. McRae? All right, you may continue. Thank you.
And so then I guess after high school, y'all kind of start having some type of romantic relationship.
Just like in 21, I want to say. Right?
Okay. And then that doesn't work out, and then she leaves the relationship and goes with her baby daddy.
Yes.
Okay. And so I guess throughout that time, are you saying that you didn't have any communication with her? Or was it kind of like a back and forth thing, or what?
Well, she always lived with him. Like, it was just like lies. I just had to catch her, So that's what made us really fall off the map.
Okay. And then in 2022, she files for that protective order.
Yes, ma'am.
Okay, and are you aware that the basis for that was that she was alleging that you had assaulted her
Yes.
and said that your homeboys were going to shoot up her and her mom?
Yes.
Okay. And so then you're saying that you were aware that you were served with paperwork for the protective order, but then nobody followed up with you.
Yeah, I know. Yeah, they came one time. They did come to my house. It was a constable.
Okay.
Came one time.
And so what they served you with was the temporary protective order that gives you the date to show up to court,
Yes.
right? And so you didn't show up in court, and then that's how that default judgment occurred, right?
Yes, ma'am.
Okay. And so then that default judgment is entered, and so that's for you all to not have contact with
Yes,
each other
ma'am.
at all.
Yes, ma'am.
And then we come to the date of the offense, and then does she communicate with you by phone, or how does she?
Text now.
Okay. And so what was the conversation?
Asked me to come here. I don't remember. It was totally different from when I jumped in the car just to come and talk with her. And then she let me know what was really going on as soon as I jumped in the car.
Okay. So did she let you know once you're in the car that Santos, that's her big daddy, correct? That she suspected that he was messing around with another girl
Yes.
and that she wanted to go roll up on that girl, correct?
Yes.
Okay. And so she had what, a white motor vehicle at the time?
It was a blue Taurus.
Oh.
Yeah, like a blue Taurus.
Okay. And so she's driving the motor vehicle and you're in the passenger seat, correct?
Yes.
Okay. And then you have your firearm, correct?
Yes.
And so then she drives to Santos' house, and that's initially where she sees the girl, the victim in this
I
case.
wasn't in the car at that time when she was doing all that. She had came to get me, and when we came to the light on Medina Base, that's when she saw the car and we followed the car.
Okay, so you're aware that she testified. That's what she said.
Yeah, of course.
Okay.
Yeah,
And that's not what the girl said.
Yeah, I wasn't in because I don't really. Well, it's like I can't put that in there, but they used to follow me around like the baby daddy and the dad type stuff. You know what I mean? Trying to see who I was. So I didn't go around there people's place like that. They had kids and stuff. I wasn't into all that.
Okay.
It's just
So
as soon as I jumped in the car, we got to Medina Base, and that's when we started following the white car. Like you gave me Medina Base is Elm Valley coming down. It's Medina Base. I live on Medina Base. You know what I mean? It's literally walking distance. Like I could literally get there like that. Like.
So then after she scoped Bianca out at Santos, across from Santos' house, then it's your testimony that she went and stopped and picked you up and then resumed following the car.
Yes.
That's
Pick me up.
saying?
Yes. Pick me
Okay.
up.
Okay. So notwithstanding that, then you will end up at the victim's home.
Yes.
Correct?
Yes.
Okay, and when y'all arrive at the victim's home, Tiffany gets out of the car and punches the victim, correct?
Yes. Yes, ma'am.
And they're engaged in an altercation, correct?
Yes, ma'am.
And you were saying that you were trying to separate.
Yes. Several times.
Okay.
Like 6, 7 times.
Okay.
5 or 6 times.
And so you said that you don't know the victim in this case, correct?
No.
And that you've never seen her before,
Never in
correct?
my life.
And so why she has no incentive to make up anything about you, correct?
No.
So then why would she tell the police that you curb stomped her?
Exactly. That's what I'm trying to get to the bottom of it. Yeah, I'm strong. So just imagine me putting somebody's face on the curb and what you know what I mean? She'll lose teeth, all that.
I mean, her lip was busted.
Yeah, but from Tiffany, yeah, it was a baby bust.
Okay,
Yeah, of course. I seen the video.
Bust.
Yeah.
It's a baby bust.
Well, I don't know how to really tell you, but I didn't punch her. I don't punch women. I just can't tell you that part.
You don't punch women.
I
but
don't.
Tiffany's made reports
That I punched her,
that
right?
you assaulted her.
Yeah, and that I tried to kill her and the most and all this and that. But
So is it?
why would she?
Testimony?
She obviously trusts me, right?
So asking the question. So it's your testimony that just all these females make up these accusations.
I don't know all these females. I just know Tiffany. I don't know the other girl. I just know Tiffany and what I've been through with her, to be honest.
And so while Tiffany is engaging in this physical altercation with the victim, you're saying you didn't curb stomp her, but you pull your firearm out, correct?
Yes.
Okay, and you fire your firearm. You're
Yes.
not disputing that, right?
Fired her.
And in fact, there's Ring doorbell camera that catches the audio
Yes,
of it, and the victim is yelling, please stop.
Yes.
Y'all are not stopping, correct?
Yes.
Okay. And then at that point, that's when the victim goes to try to take the picture of Tiffany's license plate, correct?
Yes, ma'am.
And then Tiffany snatches the phone from her,
Yes, ma'am.
and then y'all both get back in the motor vehicle and take off.
No, they fought actually one more time in the street.
Okay. But Tiffany ended up with the cell phone in the vehicle when y'all left, right?
Yes. Yes.
Okay. And then when y'all are on the way back to wherever you're going, then that's when the car crash happened.
Yes, ma'am.
Okay. And so it was your testimony that basically you just went with Tiffany because she said after this, she would leave you alone.
Yes, ma'am.
Okay.
To be honest.
But you're aware that when y'all got in that car crash, that multiple police officers showed up on scene, correct?
Yes.
And do you recall what you were doing?
Yes.
Okay. What were you doing?
Hugging her and stuff.
You were hugging
Kissing
her and kissing on her
Yes.
and rubbing her buttocks. You recall that?
Yes.
Okay. And that doesn't look like somebody that wants to leave someone alone, right?
Yes.
Okay. And then in fact, then when you're picked up on the warrant for this, you call her from the Bexar County jail.
Yes.
Right. And you're
Yes.
telling her, I love you. Don't worry about this. You don't have to apologize for this. You recall that, right?
I told her I was going to take accountability. Yes.
Okay.
Yes.
Okay. And so how do you reconcile that with the fact that you're saying that you just went to never have contact with her again?
Because I wasn't contacting her. She contacted me. No, I didn't. I wasn't going out of my way to contact her no more, to be honest, no. I jumped in a car, made a dumb choice, very dumb choice, obviously. I blame myself, to be honest. I just really do.
All right. And then you're currently residing with your mom and not you PSI officer?
Yes, ma'am.
Okay. And your mom is another person that you talked to while you were in Bear County Jail, correct?
Yes.
And when you spoke with her, you had already known that the police were looking for you regarding what
Yes,
happened
ma'am.
with Tiffany, right?
Yes, of course.
Okay.
Of course.
And so you told her that you were anticipating to get picked up on this and that it really wasn't a big deal, right? For her
Well,
not to
because I
worry
didn't-
about it.
Well, because I didn't do all the stuff y'all telling me I did, like curb stomping her and stuff. Yeah, of course I was telling her that, of course.
Okay. And then I guess you mentioned in the PSI too, but that your mom doesn't really like Tiffany.
Never. She's got videos of her pulling up, making her leave. You know, my mom's a Jehovah's Witness, so all the stuff that I did out there. I never did it around my mom. No.
Fair enough. And so then, when we look back at your probation that you were on in 2018, it looks like you had some problems with smoking marijuana.
Yes, ma'am.
Okay.
Yeah.
And so you've been on bond in this case. Is that correct?
Yes.
Okay. And so you told the PSI officer that the last time that you used marijuana was in 2025. Is
Yes.
that correct?
Yes.
And that's while you were on bond for this case?
I don't recall that. I just know I told her I was smoking 2025.
And so I guess in the rendition that you gave of the facts to the PSI officer, basically what you said is that you were just trying to be the peacemaker.
Yeah.
Okay. And so, I mean, you described yourself as a big man. Is that what you said?
I mean, I know what's right and what's wrong. You know that I'm like from the gate when I had the conversation with the girl, I knew it wasn't right. Like, you know what I mean? I just
But
let it go.
what I'm getting at is like Tiffany and the victim in the case are both smaller than you.
Yeah,
right?
of course, of
Okay.
course.
And so it's your testimony that in trying to separate two small females, you and your size and stature, that you needed a firearm to do that.
Well, they didn't. I didn't want to punch them or put my hands on them like that. I thought it would really scare them, to be honest. And they did. They separated and they didn't fight again. We jumped in the car, like you said, and we got past the airport and crashed at the airport.
Okay. And so then when the PSI officer asked you how community supervision could help you, you told her that it would make your mind clearer.
Yeah, like 'cause I know not to. I don't even go out after, since I've been going through all this. So I know it's just a lot that I need to do, and it'll just have my mind straight. I can focus on my people, like work harder. You know what I mean? Don't make no dumb choices like that. That was dumb.
My question is, like, did you not learn that on the other 5 probations that you've been on?
Well, things happen. I'm not hurting. Things happen around it.
But I mean, did you learn anything from all?
Yeah,
this?
of course.
Okay.
Yeah, that's why I was successful on my last probation, besides the UAs.
Okay, and so that was another offensive fight involving you firing a firearm.
Yes, ma'am.
Okay,
Yes, ma'am.
and so I would beg to defer that you didn't learn much from that if you're here because you did it again. Wouldn't you agree with me?
Well, I had the right to carry. I wasn't a convicted felon.
Yeah,
Right?
you got that right. Yeah. Now, in your probation in 2018,
Yes, ma'am.
when the probation officer was monitoring you, they were monitoring your social media. Were you aware of that?
Yes, ma'am.
Okay. And so what they saw was that you were on Facebook Live smoking marijuana.
Yes, ma'am.
Were you doing that?
Yes, ma'am.
Okay. And that's while you're on probation.
Yes, ma'am.
And then it was also notated that you associate with multiple members of the criminal street community blood, correct?
My big brother. I don't want to put him out there, but it's not me. It's just my people.
It's just people that you associate with
Yeah.
are members of criminal street.
Yes.
We pass the witness.
Any questions?
No further questions, Judge.
All right. Any other witnesses, defense?
No, ma'am.
All right. The court will hear argument. State you're opposed.
Search. Right. Patient and 6 years. in prison. Mr. Tochi did negotiate a very advantageous deal for this defendant. However, the reason that the state is opposed to his applications is due to the criminal history that I've just discussed with the defendant, which includes multiple felony probations where he's on felony probation, picks up a new felony charge, and that judge decides to continue him. He's picking up motions to revoke for continuing to use illegal substances and is continued as well, which I think leads to the problem of why we're here today. And he did notate that he's not a convicted felon, but I would beg to argue or submit that had the court done the right thing back then, he would have been sent to prison and been prohibited from carrying firearms, because it is clear by his demeanor, the things that were stipulated to and stipulated evidence, that he does not have the comportment for somebody that needs to be carrying a firearm.
Yes, sir.
I'm not talking to him, I'm talking to the court, you can face forward. Judge, he's never been compliant with his previous probations. And then if we're looking at the facts, what it was that he went over there with somebody that's not even his girlfriend to go confront someone that Tiffany Martinez, who's already been sentenced to 6 years in prison, went to go confront this girl that she thought was messing around with the father of her children. And they followed her to her own residence, they ambush her and assault her, and then he pulls out a firearm and fires it and places her in immense fear. And in PSI, she's also asking for this defendant to be sent to prison. And Judge, I just think that based on all the evidence that is before you, that I am asking you to deny its application and send to 6 years of prison.
All right, defense.
So, yeah, he's been on felony probation, Judge. I believe, if I read the PSI correctly, he did successfully discharge from it. Yes, he smoked marijuana. You know, the thing about Roger is, as the court, if the court was in tune, he's just not going to lie about that stuff. It would have been easy to say, no, I didn't smoke in 2020. It would have been easy to tell the PSI officer I didn't. Yes, he smoked marijuana while on probation back then. He probably smoked marijuana last year. Is he supposed to do that? No, of course not. But for what it's worth, Roger didn't lie about those things. And I know we've talked a lot. He can be successful on probation. It's in the PSI before you. The fact that he had one, I know doesn't bode well for him. But to say that he can't be successful on probation, to me, is just incorrect, because obviously he can. He does like to smoke marijuana. The court can address that issue. You know, the thing about talking about what happened that night is, don't take Roger's word for it. I mean, as an officer of the court, and I know the court hasn't had the benefit of reviewing all of the evidence in this case, but the complaining witness herself recorded a 911 call. She spoke to the initial arriving officers, and then she spoke later the next day with a detective. And I, as well as Ms. Galloway, have reviewed all that. And I will tell you, almost 90% of what Roger is telling you is confirmed by the complaining witness. The first thing she tells the officers is, when the girl gets there, she confronts her and she hits her in the mouth twice. And she even tells the officer, there's a cut. I'm not going to characterize it big or little, and she tells the police officers the girl did this, not Roger. The next thing she says is, Roger got out, and I am almost quoting, he separated us. He was trying to break up the fight. Those are the words of the complaining witness. She goes on to say that it did break up, and she is having probably a very heated, hostile dialogue with Mr. Mims. But she's trying to explain, I don't know who y'all are, and I am not sleeping with that girl's boyfriend. And in fact, she wasn't. And so Roger's kind of in this thing.
And where does the firing of the weapon come in?
Well, I'm getting to it, and I'll try to get to it a little quickly. But I think the context is very important. All Roger wants, Judge, is to get the hell out of there. He should never have gotten in that car. Tiffany's bad news. She's trouble. She's toxic. She is. Roger makes poor decisions, but you kind of heard how Roger grew up. And it's unfortunate that he did. And I don't know if he has PTSD. I've gotten to know him for about a year and a half now. I can speak for him, and I understand and can see what happened in that moment. But in that moment, he's trying to create resolution. He gave her property back. He didn't want to assault her. He didn't want to rob her.
What are you saying? He returned property before they left?
There was property that was not taken, but property on the ground, laying around, Tiffany's purse, stuff strewn everywhere.
I mean, like the cell phone.
Cell phone. At some point, Roger had it. He provided it back to her. Ms. Galloway can address these issues, but I'm telling you as an officer of the court, this is what the evidence was. And she tells the police officers this. They're having a conversation. And Roger is having this conversation, trying to explain things, and it goes back and forth. And the two girls, not Roger, get back into another fight. Mm-hmm. And she articulates all that. And just keep in mind, all Roger wants is for this thing to end and to get out of there. And so to that end, and I believe she believes that Roger got involved. I believe she believes that. I personally do not believe that Roger went over there and struck her. And I can tell you this, none of the injuries, because you don't have the pictures and you don't have the benefit of the video. There is no way you can convince me that a girl was curb stomped the way I know curb stomping. Somebody's head is placed upon a curb. I mean, she has a cut on her lip right here. She does have a scrape on her knee, but she was in pajama bottoms rolling around on the street. She has no injuries whatsoever to indicate that that kind of injury was inflicted by anybody. And I'm telling the court, I don't believe Roger ever did that. I believe she believes Roger may have been striking her because she's on the ground rolling, pulling hair as she pulled it or described it. Roger comes over and tries to separate the girls. And he probably did put his hands on her, and he probably did push her or even throw both of them to the side. But I can tell the court in no way do I believe whatsoever that that ever occurred. But I do believe she believes it. And I know that she told the police officers that. But the vast majority of what she tells the officers in all three statements is Roger was peacemaker. I know that's crazy to believe or to understand, but this is one of the craziest factual scenarios I've ever encountered. At some point, Roger tells them, and the complaining witness even, again, mirrors this, that Roger told them, y'all stop fighting, I'm about to shoot this gun. She tells the police that, and she even tells the police that he fired the round in the air to get them to stop fighting. He wasn't trying to, I'm sure it was scary, I'm sure it was threatening, and she certainly did feel that way. But he was only trying to get them to stop. And that's how he did it. And to look at it now, it's dumb, it's dangerous. I understand that. But Roger, in that moment, just wanted this thing to end. And that is how he did it. He wasn't trying to scare or kill or hurt or rob anybody. He wanted these girls to stop fighting, to get in the car and get out of there. And that's finally what did it. And it's wrong. And he shouldn't have done it. And he shouldn't have had that gun. But in that moment, Roger wasn't there to rob or hurt anybody. I don't believe he did. And what the complaining witness says doesn't track entirely, but it tracks a lot of what you've heard today from Mr. Mims. He was trying to break them up. He really, truly was. She says that. He was only trying to stop the fight with the weapon. She says that. And then they got out of there. In the aftermath of it all, I can't tell you, they had a big crash, a major crash. And Roger has blood streaming down his face. They did what they did, but I can tell the court he had no intention of hurting her or robbing her. He should not have been there, and he should not have had a gun. Whether the court believes he should go to prison, I will leave that to the court. Roger's biggest mistake was just getting in that car. He never should have. I wish I could give you an answer to that. I've asked him that question 100 times. That's what doesn't make sense to me. But he didn't get in the car with evil or criminality in his mind. He got injected into a situation, given his mental makeup and his life up to that point. I feel he did the best he possibly could, and thank God nothing worse happened. And the complaining witness corroborates a lot of what I'm saying. So don't take my word for it. She said the same thing. I'll defer to the court on the issue of probation. I understand how large of an ask this is, for this court, for somebody with his history and the story you've just heard. So I hope the court can see through a lot of what looks really bad and get to the bottom line understanding of what Roger's role and conduct was. And I do think it deserves being on probation. He can survive probation. I've met his girlfriend. She's really nice. I've met those young men. They're the cutest little boys. Roger loves them. He is in a good spot now. Whether the court wants to keep him on his path is up to the court. If you want to put him in prison, then that is the court's determination. But that's all I have for now, Judge. I appreciate the court's time. I know I've taken a lot of it.
State.
Judge, I have a synopsis of the statement that was provided by the complainant in this case, but if I'm hearing the argument correctly, that he was trying to be the peacemaker, but I respectfully disagree with that. And if we're looking at the vacuum of him discharging the firearm, it's kind of like they're trying to make like a self-defense argument, kind of, but it was not a justified use of the firearm. They are the ones that are provoking the difficulty. They are the ones that went to the victim's home. They are the ones that engaged the victim. And so I'm asking to deny his application and sentence him to 6 years.
And I just have one question.
Yes.
This accident that occurred afterward, was that due allegedly to speeding or something of that nature? And did that happen immediately after this?
Fight away from the location. I think what was told by the defendant and co-defendant to the police was that the brakes went out, is what was told.
It would have happened a few miles away. I wouldn't say it was contemporaneous, but it happened over by the airport. The incident itself was a few miles from the airport. The Tiffany was driving. I don't know the reason for the accident. It was a pretty big one. I don't know if that helps or hurts, but folks,
No, I was just trying to
I don't
figure
know.
that out.
It was a few miles away.
And I only asked because I believe defense in your argument, you brought up the accident. So I was just trying to figure out the connection, if there is one, between this.
I don't believe there really is any connectivity. And I'll be clear with the court that this is not self-defense at all. I know it's not. There are no defensive issues here.
Okay.
It's just what happened, Judge.
All right. This is what the court is going to do. Counts 4 and 5 will run concurrently. The court will find the defendant guilty of counts 4 and counts 5. Does anyone wish to speak to the cap?
Yes, if the court is contemplating a term, Judge, obviously I would ask for something in the lower range of the term. Again, I really truly believe I know Roger had no intent on hurting her or robbing her.
Well, I mean, the lower range for this offense, I believe, is 5. Isn't this aggravated robbery?
He entered.
Can I see the paperwork again? I'm so sorry.
I believe it's between 2 and 6, Judge.
Yes, Judge. They're
All
both.
All right. Thank you. I'm just trying to see what the police did.
They should be third degrees.
Yes, I see here. That is counts 4 and counts 5.
Mr. Mims has never been to prison before. I do think he had a very, very different role than the co-defendant who you assessed a 6-year sentence for. I do believe that Roger did make considerable efforts to try to alleviate that horrible situation. And I do believe that does hopefully warrant some consideration from the court if you're going to assess a prison term.
All right. And state you're asking for? All right. And count 4, court will sentence you, in counts 4 and counts 5, the court will sentence you to 5 years in the prison, give you credit for any time served. There's to be no contact with Tiffany Martinez or Bianca Gonzalez. Counts 4 and counts 5 will run concurrently. Is there anything else? You're welcome.
No, ma'am. No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? All right. Good luck to you. Thank you.
Shapiro.
Thank you, Your Honor. Your Honor, if it please the court, we're before the court this afternoon in the matter of the State of Ohio versus Theon Rufus, case number 25 CR 896. The defendant is present in the courtroom with his attorney, Mr. Rozell Hurley. We're before the court for purposes of a change of plea in accordance with a plea agreement that's been reached between the parties. And if it pleases the court, put the terms of that agreement on the record.
Please.
Your Honor, pursuant to the agreement, the defendant would withdraw his previously entered pleas of not guilty and would plead guilty to a lesser included offense of count 4, that being an attempted felonious assault, making it a felony of the 3rd degree by incorporating the attempt statute. Also, Your Honor, the defendant would plead guilty to count 6 as indicted. That is a felony of the 3rd degree robbery charge. The state would, after findings of guilt and at the time of sentencing, the state would dismiss the remaining charges. The state would review the pre-sentence report prior to making its sentencing recommendation. The state could recommend any available sentence. The defendant would not have to join in or agree with whatever the state's sentencing recommendation ultimately is. The defendant could request any available sentence. It's my understanding the defendant would be requesting community control or probation in this matter. Restitution would be requested by the state, if any, in an amount that's not yet known to me. The state would, well, that's it, Joe.
Thank you.
So, that's it. Thank you, sir.
Is this yours, or are you doing this for Mr.
No,
Mel?
this is me.
Okay. I had Josh's name on here for some reason. Or maybe he was doing it for you early on.
There may have been a prior hearing that he was covering
Yeah.
for me, but this is my case, Your Honor.
Okay.
Thank you for asking.
All right, Mr. Hurley, does that all sound accurate?
That's correct, Your Honor.
All right, and Mr. Rufus, were you able to hear what the prosecutor and your lawyer just acknowledged as to what they believe your intentions are here today?
Yes, Your Honor.
And you guys can be seated during
Okay,
this
yeah.
time. It doesn't, I don't interpret that as any disrespect. It takes a little bit of time to do this, so it's easier to be sitting down when we're doing this. So you're able to hear what they said?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previous entered plea of guilty to count 4 and 6, plead guilty to a lesser or reduced charge of count 4, as well as count 6, and I'll go over those with you to make sure you understand them.
Yes, Your
All
Honor.
the other counts would get dismissed pursuant to the agreement. We would defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they feel is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here.
Yes, Your
I
Honor.
need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your
All
Honor.
right. Give me 1 second here. All right, let's get started then. How old are you, sir?
44, Your Honor.
Are you able to read and write the English language?
Yeah, I'm not a very good reader. I can read, though, Your Honor.
Okay. There's going to be some point in time when you have to go through some paperwork. Can you assure me that if you're having any difficulty reading it or understanding what you're reading, you'll ask for assistance, you'll ask me, you'll ask your lawyer, but you'll ask for help in that regard?
Yes, Your
All
Honor.
right. Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
I don't do drugs or alcohol, Your Honor.
Okay. What about, so what in the last 48 hours? Nothing?
No, Your Honor. My anxiety pill.
Well, that's my next question. I was going to ask you even about prescribed medication. So not necessarily illegal drugs, but even legitimate prescribed medication. Anything in the last 48 hours.
I take one this morning.
Okay, so it's
My anxiety.
Okay. So anxiety medication?
Yes, I forgot the name. It started with a HY or something, sir.
Probably hydrochloroquine or something like that.
TriPoint had gave it to me. They said I overthink too
Okay,
much.
but it's for anxiety.
Yes, sir.
I'll just list it as anxiety medication.
Yes, sir.
Okay.
I mean, Your Honor.
You took that this morning the last time?
Yes, Your Honor.
Anything else?
No, Your Honor.
Does that anxiety medication in any way negatively affect your ability to understand or appreciate where you are, what's going on around you? Does it hurt you, hinder you in any way?
It just calms my thinking down, Your Honor.
So if anything, it helps you, I'm assuming?
Yes, Your Honor.
So it doesn't make it more difficult for you to understand or appreciate what's going on around you, does it?
No, Your Honor.
Okay.
Very aware.
Okay, good. Now, you would have received a copy of this indictment sometime back in October. That's the document that sets forth the charges you're accused of committing. Do you remember getting that at some point?
Yes, Your Honor.
And you had a chance to look that over at some point?
Yes, Your Honor. I had.
I know it was a while ago, but
I tried to get them back because I had put it in my T-shirt, my paperwork, because they was moving me,
oh, the indictment?
and they went downstairs, and they wouldn't bring them back up to me, Your Honor.
We'll make you a copy to bring back with you if you want.
Thank you, Your Honor.
But you did get it at some point?
Yes, I did. Yes, I did.
Well, so in that indictment, there's 9 counts. You're
Yes.
going to plead guilty to 2 charges. I'm going to go over those with you. In count 4, what's alleged, now this is one you're pleading guilty to, but what's alleged in count 4 is on or about March 31st, 2025 in Lake County, Ohio, that you did knowingly cause, this is going to be what, attempted?
Yes, but there was actually an injury that was caused here. So it's not an attempted attempt.
So you're going into a different subsection then?
No, it's just that it would be the same subsection because there was physical harm caused by a deadly weapon, but it wasn't an attempt because it was actually completed. You see what I mean?
I see what you mean, but it doesn't matter if it was completed. Attempt is built into the statute.
Well, if factually there was physical harm, like if the indictment could read that he did cause physical harm while committing a theft offense, and it wouldn't be an attempt. So,
Wait, hang on. Maybe I'm looking at the wrong charge. This is attempted felonious assault.
it is, Your Honor.
So it doesn't matter if it was done during a theft offense or anything. Did you just say it was done during a theft offense?
Yeah, I did. What I mean, I'm sorry, Judge, and let me have this down. We're looking at number 4, Judge, count 4. Forgive me.
Yeah.
Right, I'm sorry, I have it backwards in my head. When Your Honor asked me to recite the facts of this, the facts include that the defendant had a Swiss Army style knife that he caused an injury to the victim's hand with. So it is actually a completed physical harm here. It's not an attempt.
I get it, but an attempt is still this charge.
Well, if I amended the charge to say that he did knowingly cause physical harm to another, would that, you see what I mean?
It should be, he attempted to cause serious physical harm to another.
No, because it's a deadly weapon, Your Honor. Isn't it just physical harm?
But if you go under A2, A1 is knowingly cause serious physical harm to another. An attempt at that, we're going to have 3. And why can't that be supported by the facts if he took a knife and swung it at somebody? An attempt to cause serious physical harm. Not that he caused serious physical harm.
Well, no, I suppose.
But he attempted to cause serious physical harm.
Right.
I mean, I think anytime someone takes a knife and uses it, that's an attempt to cause serious physical harm.
I agree with that, Your Honor, and I would say that is the case. I agree with that.
I'm just saying that whether you cause harm or attempt to cause harm with a deadly weapon, it's a felony second degree.
Yes, Your Honor. But if we incorporate the attempt statute, that makes it the F3.
This isn't.
You see what I mean? Like we're
No, I just don't agree with
No,
that.
no, I'm-
There's case law right on point with that.
well, even if, but it's, it's just physical harm on the A2, Your Honor. Cause or attempt to cause physical harm to another. And here in this case, we have a situation where the defendant did knowingly cause physical harm to another. So if we incorporate.
But it doesn't matter if he did or not, it's still enough too.
I thought if we incorporated the attempt statute when harm is actually caused, that is allowable under the law, Your Honor, to make it an F3.
So what are you saying? He attempted to cause physical harm with a deadly weapon.
I'm saying he caused physical harm with a weapon. He caused a half-inch
Right.
slice on the hand with a Swiss Army style knife. So
So-
what he's pleading to is an attempt to do that.
This is right in the statute.
That's what the statute says, but to comport with the facts of the case, if I was to move to dismiss or attempt to cause, isn't it still a felonious assault if it did knowingly cause physical harm to another?
Yeah. But if you're going to say that's not the case, he attempted to cause physical harm to another, that's what you're saying with the plea.
No. Well, right, but by incorporating the attempt statute. I understand. I think I know what you're saying now, Judge, but what I'm saying is factually here, we're not trying to do an attempted attempt in reality. Like this is in reality, there was physical harm here. It was a half-inch cut on the
I
hand.
hear what you're saying, but all I'm saying is that an attempt to cause physical harm with a deadly weapon is a felonious assault. But I'll go along with it.
Well, I apologize for not highlighting that earlier and clarifying.
I just
Your Honor.
think it'd be cleaner if you just did attempted felonious assault under A1. Attempted to cause serious physical harm. Period.
Well,
That's an F3, attempted felonious assault. That's a legitimate offense.
well, if there's no objection.
No, I mean,
Yeah.
I'll do whatever you guys agree to. I'll just.
Well, Your Honor, the A1 section is not indicted here, so in order to accomplish that, we would both have, Mr. Hurley and I would have to agree.
Well, I mean, we do that stuff all the time in terms of pleading the offenses that the person is not charged with. I'll go along with what you have. So, Mr. Rufus, what's alleged here? Let's start over. I'm sorry for the delay there.
I'm sorry, Your Honor.
On or about March 31st, 2025 in Lake County, Ohio, it's alleged that you knowingly caused or attempted to cause physical harm to another by means of a deadly weapon, specifically a knife. And actually what's alleged with the facts in this case is that you did cause physical harm to another person with a deadly weapon, the knife. That's what you're charged with. That's not what you're pleading guilty to. That's what you're charged with.
Yes, Your Honor.
That constitutes the offense of felonious assault. It's a felony of the second degree. Now, for purposes of the plea today, the state is willing to let you plead to a lesser included offense of attempted felonious assault, which means that you engaged in conduct that, if you were successful, would result in the commission of the offense of felonious assault. So it means that you engaged in conduct that, if you were successful, would have resulted in the victim suffering physical harm by means of a deadly weapon.
Yes,
The
Your Honor.
significance of that is that it reduces it from a felony of the second degree to a felony of the third degree, which is a substantial difference. A felony of the second degree, there's a presumption for prison. If it's indefinite prison term, you have a minimum and a maximum sentence, and you could get up to a sentence of 8 to 12 years in prison. With this charge, there's no presumption for prison, and the maximum sentence is 3 years in prison, or 36 months. So you understand the difference between what you're charged with and what you're pleading guilty to?
Yes, Your Honor.
Any questions?
No, Your Honor.
You have listed here the theft statute in here, 292302.
It should say 23.
It should say 292302.
Yes, did I write 2913?
Yeah.
I apologize.
Sorry.
2923. Excuse me, Your Honor.
That's all right.
I'll have it on mitigation.
Now in count 6, what's alleged here and what you're pleading guilty to is on or about March 31st, 2025 in Lake County, Ohio, that you did in attempting or committing a theft offense or in fleeing immediately after you attempted or committed a theft offense, that you attempted to inflict or threatened to inflict physical harm on another person. That conduct constitutes the offense of robbery. It's a felony of the, I'm sorry, I read the wrong one. That was count 7. You're not pleading counts, you're pleading to count 6. Let me start over. Count 6, what's alleged here and what you're admitting to, is on or about March 31st, 2025 in Lake County, Ohio, that you did in attempting or committing a theft offense or in immediately fleeing after you attempted or committed that offense, used or threatened immediate use of force against another. That conduct constitutes the offense of robbery. It's a felony of the 3rd degree. Do you understand what you're charged with in pleading guilty to in count 6? Do you understand what that charge is?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
Well, then before I can accept your guilty plea to these 2 charges, I need to make sure you understand all the rights you are giving up. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And that will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those jurors will make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together one way or the other as each charge whether you were guilty or not guilty. You understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Having the burden of proof means that it is his job, or he bears the responsibility or the obligation to prove you guilty before you could ever be found guilty or presumed innocent of all these charges. And that presumption of innocence stays with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, I speak of the burden of proof since this is a criminal case. That burden we call proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What that actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of the charges beyond any reasonable doubt before you could ever be found guilty of any of these charges at a trial. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, if we had a party, the prosecutor would bring witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. And that's called cross-examination. So he could ask them anything he wanted to, but within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that.
Yes, Your Honor.
You're not required to do that. But you have a right to do that if you want. Do you understand that?
Yes, Your Honor.
And you further have a right, if there was some people out there that you wanted to have come in and testify for you that weren't willing to come in on their own voluntarily, you could request this court issue an order that we call a subpoena. A subpoena would force them or make them come to court to testify for you and answer your lawyer's questions if, again, they weren't willing to come in voluntarily. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That is a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial If you didn't want to, I can't make you testify. But more importantly, the prosecutor here is not allowed to make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge the guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you've given up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty in this case to 2 felonies of the 3rd degree. Each of these are punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30. So if I impose a prison sentence on these 2 counts, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36. It doesn't have to be the same for each count. It could be different. But that'd be the number of months you'd have to serve in prison for that particular count. Do you understand that?
Yes, Your Honor.
Now, since there are 2 offenses here, if I impose the prison sentence, I would impose it on each count. Then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together or at the same time. You'd serve them both at the same time. Consecutive means one after the other. You'd serve the prison term on the first count, finish that, then on the next count. You understand the difference there?
Yes, Your Honor.
So in this case, if I impose the maximum sentence on each count, it will be 3 years, and I ran them consecutive, you're looking at the maximum possible prison term of 6 years in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole or supervision to any other courts or agencies?
No, Your Honor.
Do you have any other charges pending against you anywhere?
No, Your Honor.
If a prison term was imposed in this case, upon your release from prison, you would be placed on what's called post-release control, sometimes referred to as parole or PRC. It's a period of supervision you would be on after you serve the entire prison sentence. And in this particular case, it would be for at least 1 year. It could be up to 3 years. It's up for the parole authority to decide that. Do you understand
Yes,
that?
Your Honor.
And if you're on post-release control at any point, you ever violate any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence I just explained, there's other penalties that can be imposed. You could be fined. There's no mandatory fine, but you can be fined up to $10,000 on each count. So it's a maximum possible fine of $20,000. You could be ordered to pay restitution to any victim for any economic loss any victim may have suffered. And you could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison's not mandatory with either of these charges or required. You are eligible for probation or what's called community control sanctions, and there's no presumptions one way or the other. It's up to the court to decide that. And when I say presumptions, that means there's no presumption that you would be put on probation. There's no presumption you would be sent to prison. It's the court's discretion. You understand that?
Yes, Your Honor.
Now, just because you're eligible doesn't mean you automatically be put on probation. It means I will consider that if that's what you're requesting. I'll look at all the information presented to the court, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you were put on probation, it could be for up to 5 years of supervision. As a judge, I would have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, Your Honor.
Further, if you were put on probation in this court and you ever violated any of the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could order more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did it at that point, again, it could be 9, 12, 18, 24, 30, or 36 months on each count. That could be consecutive for up to 6 years in prison, which could also be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor could also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him go over everything with you and read the report for you and answer your questions?
Yes, Your Honor.
Has he or anyone made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your actual plea?
No, Your Honor. He told me everything he wanted to tell me.
Yeah, but do you have any questions for him?
No, I just wanted to tell you I take full responsibility of
We're going to get to that in 1 second here, but I just want to make sure you don't want to discuss anything with him before we get to that point. You're good?
Yes, Your Honor.
So then what's going to happen at this point, the prosecutor is going to explain for me what he believes the evidence would show if we had a trial. I want you to listen to him because then I'll have some questions for you about that, all right?
Yes, Your Honor.
Shapiro?
Thank you, Your Honor. March 31st, 2025, a man named Lavelle Rucker was seated in the driver's seat of his car, Mr. Rucker's car. Defendant approaches Mr. Rucker's vehicle, threw a rock through the window, smashing the glass, and he also, with a small red Swiss Army style knife, slashed Mr. Rucker's tires. Mr. Rucker opened his door to get out. At that time, the defendant stabbed at Mr. Rucker's hand, causing a half-inch injury to Mr. Rucker's hand with that knife. Mr. Rucker got back into his vehicle. That's not true. Then Mr. Rufus grabbed Mr. Rucker's left prosthetic leg. Mr. Rucker has a prosthetic leg from the thigh down. Mr. Rufus then took Mr. Rucker's leg without permission. He wasn't allowed to take it, and he stole it, and he got out of there. That's it.
Mr. Rufus, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show if we had a trial?
Yes, Your Honor, I heard it.
And what, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
I take full responsibility of the choice that I made, Your Honor.
Okay, so my question is, though, are those facts that he just
It was-
represented, are they true?
Yes, it's true, Your Honor.
Very well, then regarding the lesser included offense, a reduced charge of count 4 being attempted felonious assault, a felony of the 3rd degree, what is your plea to that count?
I'm guilty, Your Honor.
And regarding count 6, charging with robbery, a felony of the 3rd degree, what is your plea to that count?
I'm guilty, Your Honor.
All right, I have in front of me now, this is the paperwork I was talking about before. It's a 4-page document that sets forth everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand this document and that you then sign it here in open court. Now, my understanding is, before I came out here, you had a chance to go over this document with your lawyer, is that correct?
Yes, Your Honor.
So did he read it to you?
Yes, we went over it, Your Honor.
I'm sorry?
Yes, we went over it, Your Honor.
Did you understand it when you went through it with him?
Yes.
Any questions for me about it?
No, Your Honor.
Mr. Hurley, is that accurate? Did you read this over with your client, review it with him, answer his questions?
Yes, Your Honor, we read it in the holding cell, Your Honor.
Okay. Did he indicate an understanding of it to you when you went through it?
Oh, yes, Your Honor.
And again, that's correct, Mr. Rufus?
That's correct, Your Honor.
And Mr. Rufus, that's correct?
That's correct, Your Honor.
Do you have any questions for me about it?
No, Your Honor.
Now, it also appears that you signed the document. Did you sign it?
Yes, Your Honor.
Mr. Hurley, you witnessed that signature?
Yes, Your Honor.
And Mr. DePiro, you did as well?
I did, Your Honor, and if I may, I don't remember if I said that this happened in Lake County, Ohio, when I said the facts. This was in the city of Painesville, right down the street by Sheets.
That's correct, isn't that, Mr.?
Yes, Your Honor.
Thank you.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect, the defendant was here in open court. His lawyer advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of the lesser included offense of count 4, being attempted felonious assault, a felony of the 3rd degree in violation of 29-2302 and 29-0311A2, as well as count 6, robbery, a felony of the 3rd degree, violation of 2911.02A3. All the remaining counts of the indictment will get dismissed at sentencing, but we're going to defer sentencing. I'm going to order a pre-sentence report investigation and victim impact statement. Is there any other reports that you would like or evaluations you would like, Mr. Hurley? Drug and alcohol evaluation or psychological evaluation?
No, Your Honor. My client, I don't know if you can make this request, but he dealt with Kimberly in the past. He wanted to know if he can deal with her again.
Deal with who?
Kimberly in probation. He said.
I don't know how they.
Yeah, I understand.
It depends on where the offense was, and
I understand.
I don't direct who does, but is there any? Did you want a psychological evaluation or drug and alcohol evaluation?
No, Your Honor.
Okay. Any issues with any of that? Do you want to explore it all?
What that mean, Your Honor?
Like a mental health evaluation, if there's mental health issues that you're concerned with, or drugs and alcohol. You said you didn't use drugs or alcohol.
I don't do drugs.
But I don't know if there are any mental health issues that you want to.
I go to church, Your Honor. I don't drink or do drugs on the outs.
Okay. All right, then we'll just do those 2 reports, PSR and victim impact statement. So you're going to meet with the probation department. It's important to be open and honest with them when you meet with them.
Yes, yes, Your Honor.
They're going to check and verify everything you tell them, all right?
Yes, Your Honor.
All right. Anything else for the record at this time?
Not for me, Your Honor.
Mr. Hurley?
Yes, Your Honor. I know this might be a swing for the fence, Your Honor, but I was wondering if the court would consider reinstating the bond pending sentencing, Your Honor.
Bond's going to remain at what it is right now.
Okay, thank you.
All right.
All right, who did you say this is, Mr. Rainey?
Judge, this is Mr. Barentine here on a motion to terminate court-appointed counsel.
All right, court calls cause numbers CR 25-130, 192, 193, 194, 226, and 277. This is the state versus Joseph Lee Barentine. I think we're also set for pretrial today, Mr. Manning. Let's take up pretrial.
There's actually, I'm sorry. It looks like we are set for pretrial on 4 of those cases. It appears on CR 25-277 that he may have been arraigned. The note is unclear, but he may have been arraigned on that at our 12-4 docket. I show it's our first setting on that.
Yeah, so he was arraigned 12-4-25.
Yeah, we arranged.
Okay, I just noted that was our first sitting, so Judge, I guess Mr. Valentine has filed a motion on January 5th with this court in all cause numbers alleging a substantial breakdown in attorney-client relationship, as well as conflict of interest, that his interest would be best served by removal or voluntary removal of counsel, and that he freely and knowingly consents to the termination and asserts that any such denial will result in a filing of formal grievance with the state bar. It's my understanding that speaking with Mr. Barentine that he has already filed a grievance at this time, and I told him at this point I would probably agree with him in section 1. There's been a substantial breakdown in attorney-client relationship. That occurred in our last court setting when I conveyed to him the state's offer of 50 TDC for resolution of these cases. So due to the nature of the possibility of pending litigation, I'm not going to address any other aspects other than agree with Mr. Valentine that for section 2A, that there has been a substantial breakdown in the attorney-client relationship, specifically in regards to communication.
Well, I need more information than that. So you're going to expound upon what is the root cause of the breakdown of communication. Is it because you're refusing to communicate to him? Is it because he's refusing to communicate to you? Is it because there's a fundamental disagreement on trial strategy? What is the failure to communicate?
Judge, if you'd like, I'll allow my client to answer those questions.
Mr. Barentine, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Barentine, I'm going to allow you to testify for a very limited purpose of arguing your motion to terminate court-appointed counsel. I would caution you that anything that you say that could divulge any type of attorney-client privileged communications, if you say it out loud, then you've waived it. You talk about what you and Mr. Manning talk about as trial strategy, then that's waived. Okay, we're in open court here. I've admonished you. So you're free to tell me why you think the court should grant your motion to terminate Mr. Manning as your court-appointed attorney. But that's my warning to you is
yes, sir.
Not divulge what your defenses are or to divulge what you've communicated to Mr. Manning in confidence that he can't even disclose because the privilege belongs to you as the client. Do you fully understand my warning?
Yes, sir.
All right. So let me ask a few questions before I let you speak. Mr. Barentine, do you have the ability to hire your own attorney?
No, sir.
You've asked the court to find you indigent, is that correct?
Yes, sir.
The court has found you indigent and the court has provided you an attorney, Mr. Manning. Mr. Manning,
yes, sir.
Mr. Manning's being paid by the taxpayers of Van Zandt County. You understand that?
Yes, sir.
You're not paying anything for your representation. You understand that?
Yes, sir.
Your family's not paying anything for his representation. You understand that?
Yes, sir.
You understand that Mr. Manning does not represent your family. You understand that?
Yes, sir.
Mr. Manning is not under any obligations to communicate with your family or anyone else. He represents you and you alone. Do you understand that?
Yes, sir.
All right. With that warning and me understanding what you understand, go ahead and argue your motion to terminate.
He's communicated me one time in 6 months, and that was in the very end of August. He's communicated with me only one time in 6 months. We haven't discussed any trial strategy or anything.
That's your whole reason for the motion?
When when we met in August, he's instructed to file for bond reduction and examining trial. He hasn't done any of these things. Any of the things he was instructed
He hasn't come back to see me to discuss that since then. We spoke one time in August.
Okay, is there anything else?
No, sir.
Mr. Manning, would you like to respond?
Judge, if I may, I'm just pulling up one quick thing, Judge. Yes, Judge. Just briefly, Mr. Barentine was arrested on August 15th, 2025. I was appointed shortly after that. I believe my records actually show that I visited him on September 5th of 2025. At that point in time, the charges that were pending against Mr. Barentine range from manufactured delivery, possession of controlled substance, penalty group 1, 200 grams to 400 grams, 4 grams less than 200 grams, 4 grams less than 200 grams, ag assault against a public servant, unlawful possession of a firearm by a felon, manufactured delivery PG3, or 4 less than 28 grams, evading arrest detention, as well as possession of marijuana less than 2 ounces. Discussed both the charges, the bonds, as well as remedies with Mr. Barentine at that point in time. And it was after that point that on September 19th, about 2 weeks later, the state first filed their indictments for aggravated assault with the public servant, both counts, and on the unlawful possession of a firearm by a felon. It was later determined that they filed on October 17th, 2025, a manufactured delivery, controlled substance greater than 200 grams, less than 400 grams, and subsequent indictment on November 21st of manufactured delivery over 200 grams, less than 400 grams. As I explained to Mr. Barentine in our court settings, we've had 3 court settings since on the oldest cases. As I explained to him both the arraignment process and the pretrial process, I explained to him the bond law as it applied to his unindicted cases and indicted cases, as well as the lack of credit that he would receive on any of those cases were he still being held on any single case that had not been given a bond on. It was shortly after that he made it aware that he was unhappy with my representation. And at our last court setting on September 4th, he let myself and the court know that he wished to terminate me. He filed his motion on January 5th. And at this point in time, based on the information that he provided in our conversations, as I said before, I would agree with him that I believe that at this point in time, our ability to effectively communicate and for me to represent him has been compromised beyond repair.
What is your reply or response to his allegation that the basis is that you've failed to follow instructions and only meet with him one time during the course of your representation?
Judge, I've met with him one time specifically prior to the indictments, but I have met with him each and every time he's come to court, and we've discussed aspects of his case, and I've provided responses to particular strategies of why it would not be in his best interest to file bond reductions on cases that have already been indicted.
Okay. What about his indication that he's instructed or requested an examining trial?
Yes, Judge. As I mentioned, the first case that was indicted was filed 2 weeks after my first meeting and appointment to Mr. Barentine's case. As the court's aware, an examining trial is for a probable cause determination of a case prior to indictment. And so therefore it was not applicable in those first 3 cases. Since that point in time, his attention had shifted to the bond issue, which I continue to explain to him that the law did not permit him to receive PR bonds on those particular cases. His bonds were set, by my recollection, at what I believe the courts and case law would indicate are reasonable bonds, with the highest bond out of all his cases being $50,000 down to $5,000 on the misdemeanors.
All right, so Mr. Barrington, what are you wanting me to do? You're wanting me to you wanting me to terminate Mr. Manning's representation of you that you're not paying for, and you're wanting me to appoint another attorney?
If at all possible.
Who do you want me to appoint?
I'm not aware of the attorneys that we have. At this point, anyone other than Mr. Manning. Our communication. Anyone other than Mr. Manning.
Have you already filed a grievance on Mr. Manning?
Yes, sir. Your Honor, I have. Yes, Your Honor.
Why'd you do that?
Because his failure to take action on what he was instructed to do. I instructed him in that meeting in September 5th to please file for the examining trial. This is prior to any indictments. I instructed him to please file for the examining trial. Please file for any bond reductions or PR bonds that are possible. This was in September. I asked him to do that before any of the indictments even came. And his lack of action has caused irreparable damage between us. We can't communicate anymore.
And why is it irreparable?
Clearly, his modus operandi is not in my best interest.
What is his modus? What is
his modus
operandi?
It's clearly not in my best interest.
Well, I'm saying, what is
that? Is motive? That's Latin for motives. His motives are not in my best interest.
Right, and I'm saying, what are his motives?
I'm not aware of what his motives are or aren't, but he's clearly not following instruction or doing any of the things I asked him. He's not communicating with me about it. The communication in the courtroom is minimal, and it violates any client-attorney privilege with everyone in the courtroom in here with us. That's not true communication.
And so you're saying he hasn't explained the law to you. He hasn't explained the bail issues to you. He hasn't done any of those things. That's what you're saying?
Not in a manner that I can fully understand. Not in the actual environment that provides a proper attorney-client privilege.
And have you been in court before? And are you in a position to know all about the attorney-client privilege and how it should function and not function?
I just know that the room full of people in here with us isn't any kind of privacy where he could really explain to me anything fully where I could understand it properly.
So your first, your decision was then to file a grievance against his law license, rather than discussing it with him or the court. You filed.
He won't discuss. He won't communicate with me.
Did you try to?
If there was, yes, Your Honor. Yes, I have tried.
How did you do that?
I've tried to contact him, and I've had family try to contact him.
When did you try to contact him?
Multiple occasions.
How so?
On the phone, multiple times.
Okay.
I've had my family email him also, and he refuses to correspond.
And you understand he doesn't have to correspond with your family because he doesn't represent your family.
I understand that, but he does have to correspond with me, or we need to not be.
Did you email him?
How can I email him from the jail, Your Honor?
You can't email from the jail?
No, sir.
Judge, I will agree with Mr. Barrington. For some reason, the jail system does not permit them, while they're in custody, to email their attorneys. I think that's would be a useful tool for us to have, but it's not currently available. However, I would respond to Mr. Barrington, his assertion that his family has reached out and emailed me, as I have just once again reviewed my email inbox and have no emails regarding Mr. Barrington from anyone other than the court and the prosecutor's office.
All right, Mr. Barrington, I want to grant your motion to terminate court-appointed attorney. And I don't know who I'm going to be able to appoint to you. I don't know if I have anyone. So you may be sitting there for quite some time without an attorney. I'll do my best, but I can't guarantee you that it'll happen soon. So
that's okay. Thank you, Your Honor. I appreciate it.
You're welcome. All right. Court is going to set Mr. Barrington for pretrial on April 2nd in all cases, and also for status of court-appointed attorney. Mr. Barentine, I would implore you to reach out to your family and try to pull together your resources so that you can hire the attorney that you want, so that you can boss whoever you want to boss around at your dollar.
Yes,
Understand?
yes, Your Honor.
Judge, we have Mr. Pelosa at
Okay.
the seat.
All right, I'll call State of Kansas versus Gary Michael Pelosa, case numbers 26 CR 25 and 26 MR 19. And actually, that's an extradition issue. So we'll take up 26 CR 25 initially, and depending on how that gets resolved, then we'll proceed on to the extradition. So if counsel would state their appearances, please.
Jerry Gear on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Gary Pelosa. Mr. Pelosa does appear from the Butler County Detention Facility. Judge, I do have an announcement to make. I have met with Mr. Pelosa. We've discussed his case. During that discussion, he did make it clear he wanted to represent himself rather than have counsel. We discussed that at length, as well as he has then thought about it longer overnight. So we've had a breakout room. We've discussed it again here today. And I can tell the court he does wish to represent himself and not have counsel. So based upon that, Judge, I'm asking the court to allow me withdraw.
Okay, Mr. Pelosa, is that accurate?
Yes, sir. I didn't know we weren't going to be in court today. I have motions here that I don't know how to get into court because the jail don't have mailing envelopes. I thought I was going to be in court so I can give it to your clerk. And I'm going to need to ask to push this maybe forward so I can find a way to get it into the court.
Well, Mr. Pelosa, what you're discussing is one of the complications of representing yourself. What's your educational background, sir?
I've got high school and two years of broadcasting school, and I graduated broadcasting school. So I had 14 years of school, and I had 2 years of business law.
All right. Why a person has a right to represent themselves. However, it is generally not considered to be a wise decision for most. Why is it you want to represent yourself as opposed to Mr. Patterson, who's an experienced attorney in this district? And
well, I'm going to tell you, I've advocated for prisoners in federal prison, and I have personally have gotten out 9 federal inmates myself. Also, in conjunction.
Well, generally, that's when somebody that's advocating for them, it's because they are a federal inmate of themselves. Is that correct? For you?
No. It's
okay.
Not correct for me.
Proceed.
So I'm just asking if I can get some time forward to get these documents into the court record.
Well, what's your experience in regards to filing motions and so forth?
I have a lot of experience in it, sir.
What is the nature of your motions at this juncture?
A notice in demand. It's really a notice in demand.
For?
I got evidence to bring forward. And no one's able to see. I mean, I wasn't even stopped. I was walking, but they said the registration.
Okay. Well, hold on.
I don't want to get into arguing anything. So
right. Now, do you understand what sometimes what I've done and other judges do is allow a person to represent themselves, but also have standby counsel available. Would you be receptive to that procedure?
No, sir.
Is there a particular reason why?
Right, because we haven't established the court's jurisdiction just yet. Sir, I'm one of the people, and I am the beneficiary for the defendant. You're a corporate judge, and that's a corporate attorney, and I'm one of the private people of this country. So I want to represent myself.
All right. Mr. Pelosa, are you going to be requesting a trial to a jury?
Yes, I will.
Is that one of your written motions that you have?
No.
Okay, in Kansas, on a misdemeanor, law requires a person to file a written request for jury trial. Again, on a misdemeanor offense, you're certainly entitled to that. But we set some earlier, and it looks like, well, we've got the next jury trial date is going to be February 25th. Are you going to be available and ready to go by that date? That's just a couple of weeks away, sir.
Well, I want discovery. I want the video of the officer's cam, and that's evidence in itself.
Well, and I understand that, and a certain amount of discovery is appropriate. Again, it's a lot easier with counsel, but
sir,
if you're okay, I'm going to set this matter for trial. The next date after February 28th is going to be in April, April the 8th at 9. So you could end up, remaining in jail for a good period of time. Is why I'm bringing these things up.
Okay, I'm still challenging the court's jurisdiction. I can challenge jurisdiction at any time. I mean, sir, let me ask you this question. Are you a member of the bar in good standing?
I've been a practicing judge for the last over 5 years, sir, and yes.
Okay, is the prosecutor a member of the bar in good standing?
Okay, I'm not going to go playing your games here, sir.
Well, we have a conflict of interest.
Sir, I'm going to set this matter down for hearings. Sarah, excuse me, Jen, does Judge Webster, what's her next motions date?
Are you asking about a Monday misdemeanor control or a bench trial?
No, I'm not sure how she breaks that up. You tell me, I don't know the nature of all of his motions or how long that will take, but it wouldn't be able to go on the expedited docket.
And Judge Webster would usually hear those on a Wednesday afternoon. That's when she has evidentiary type hearings.
Okay. Jen, can you look on that and see when she has next available?
The next available is going to be March 25th at 1:30.
March 25th at 1:30. So, Mr. Pelosa, at this time, I'm going to take your motion to represent yourself under advisement. I'm going to permit you to file your motions and not have Mr. Patterson do anything on that, but you need to get your motions on file. And that is one of the issues that, frankly, there's a lot of questions that, and I don't have those in front of me in regards to a pro se defendant. But we'll set that on that March, is that March 25th at 1:30?
That is correct, Your Honor.
Okay. That's when your motions will be set. You'll need to file those. You have them ready to go now, sir?
Yes.
Okay. I want those on file by March 5.
How do I get them to you?
Well, I'm not going to explain
Okay.
how you
Okay.
have to do things.
Okay.
You say you know how to do all this stuff. I cannot advise you how to proceed on your case.
I'm not asking for advisement.
Yeah, you are. You're asking for procedural questions in regards to how to do it, and the court can't hold your hand and do that. That's one of the extreme disadvantages of representing yourself. So I'm judge will take those up at that time and make her decision in regards to Mr. Patterson, but I'm not going to require Mr. Patterson to do anything further on this matter. Mr. Patterson, would you be appearing on that docket as well?
Not normally, Judge, but I did put it down. If you are ordering that I continue as standby, at least for now, I put it down.
I would ask that you be there as standby right now.
I reject that. I reject that.
I know you do. And you'll get a full hearing on it, but today's not the day on that. That was not scheduled for today. So March the 25th at 1:30. That is in regards to 26 CR 25. All right. Moving on then to the 26 MR 19. Mr. Patterson, are you appointed on that case as well?
Because it is misdemeanor charges in Missouri, then yes, it does fall on my contract. But again, I've discussed that with him and he has the same position on that too.
Is that correct, Mr. Pelosa?
Yes, sir.
You'll need to file your motions and things on that. We'll set it for March 25th at 1:30 as well. So I'm going to, Mr. Patterson will be standby counsel on that as well.
I reject that. If he wants to take the consequences of it, let him so. If not, then he needs to go.
He's not asking for that, sir. I'm ordering it. So at this time, and it's going to be the same order that I just made.
What's your authority?
You're still going to, sir, don't interrupt. You're still going to have the opportunity to do that. I'm not asking him to do anything on your behalf in the meantime, but you're going to need to file your motions, and that's going to be difficult from where you're sitting. So, file whatever motions that you feel is appropriate, and it'll get brought up at that time as well. Again, that's on Judge Webster's calendar. But if you're going to be requesting a jury trial on these matters, you need to get those on file as well, because that April 8th date is on the court docket coming up fairly soon. All right. Is there any other issues that we need to discuss concerning either of these cases for Mr. Pelosa? Mr. Regier?
Your Honor, if the court is continuing the bonds in both these matters, the state has nothing further.
Mr. Pelosa, anything further?
Not at this point.
All right. I'm going to continue the bond status as they currently are. Mr. Pelosa, if you do make bond, you are ordered to appear before the court on that March 25th date at 1:30. You're to be there at the courthouse. If it's a Zoom hearing, then they'll do it through court security, but you are to be present at that time. Do you understand?
what if I'm in another county extradited and I'm still in jail? So
That's another matter. If you're, I said if you were released, if you've made bond on your various cases, then and are released, that's the order. If you're in custody, typically these matters you take care of the local matters here that you're charged with, and deal with that, and then before a person is extradited. But so that's going to make a complication for you, perhaps, but that's your choice.
So if I may ask, the 26 CR 25 case, what is the 26 MR 19 case?
That's the extradition case.
Okay.
All right. It appears that on the 26th case, the bond is set at 10,000 cash assurity. So that'll continue to be the bond with the conditions that I just noted. Anything further concerning Mr. Pelosa?
Not from the state, Your Honor.
Very well. These matters are adjourned. Mr. Pelosa can be returned to lockup.
Thank you.
Why don't you have a seat over here? And Mr. Rivera, why don't you come on up here and have a seat. So first off, I'm going to put you under oath here. And we've all worked. I don't need you to stand up. But so first, Mr. Rivera, raising your right hand, you swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am, I do.
All right. Mr. Welch, to raise your right hand.
Yes, ma'am.
Swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Take your hat off the table. You can put it in the chair. We don't put hats on tables around here. You can keep your information. If you've got your documents or something, you can put it on the table. But I've got first a question of you, Mr. Rivera. I see you're set for trial next week, and it looks like it might be on these events that you've been charged with, and you've got an attorney in that case. Have you advised your attorney you've filed the small claims?
Yes, I have, ma'am.
Okay. So you know that you are under oath, and this is a recording, and it could be used against you in trial?
Absolutely, ma'am, yes.
Okay. And you still want to go forward today?
Absolutely, yes.
All right.
Please.
Okay. So you realize again that this could be used against you. Anything you say here can be plucked up and used by the prosecutor against you in that trial.
I am in complete compliance with everything.
Okay,
I'm
just
not
so you
worried.
know. So I just want to make sure that's your decision.
Yes.
All right. So you're ready to go to trial. Mr. Welch, you're ready to go to trial.
Yes, ma'am.
Okay. And what I've got here, and you'll notice I'm looking back and forth because everything's electronic. And so I'm looking over here to find the information that's been filed, the notice that was filed, and then I have lots of information from, let's open better. There it goes. From Mr. Welch, nothing from file, which is fine, filed by Mr. Rivera. So what I'm going to do is just turn to you, Mr. Rivera, and ask you to tell me why you think you're owed $5,000. You're asking assault, refusal of documentation, vandalism, being irate, defiant, rude. Very little of that is, yeah, that's a good reminder. Everyone turn off your phones. Your phone's off. Phone's off in the back. Okay,
Your Honor, my
that's
phone is
okay.
off right now.
It happens at least once every day. So,
That's it.
all right. So get that silent.
Sorry.
So, tell me why you think you're owed $5,000 from Mr. Welch.
Well, ma'am, on August 18th, I went to my community store. We live in Steamboat Island.
Let me slow you down. I'll get to that. But what I want to know is, what is the theory? What is it that you think you're owed money for? Just give me a capsule there. Why?
Because of the allegations that he has put against me. It's cost me to have to hire attorneys, to consult with other attorneys, because there's two matters here, a civil and a regular criminal issue.
There's another lawsuit filed other than this? There's a criminal case, there's this and another one?
I had to file against Mr. Welch.
Answer that question first. So there's a criminal case filed against you.
Yes, and
There's,
this.
you filed this and there isn't a third. Okay,
No,
so
there's
these
no
two,
third
that's
one.
what you mean. So you had to hire attorneys. What else?
I had to do a consultation just to get information because when we had this,
Consultation with whom?
I have,
I'm just trying to map out what you think you're owed.
I had a consultation with, these are all my notes, Your Honor. I'm sorry. Bear with me one moment. Connolly, Tacone, and Meserve.
Okay,
And
so that's another attorney's firm. So how much are you allege that Mr. Welch owes you for attorney fees?
I'm going to leave that up to you, Your Honor.
No, you don't. You have to prove it.
Okay.
And you have to give me proof.
I have no problem proving.
Okay, how much?
$5,000.
Okay, so you think that's what it is. So your claim is for attorney's fees.
My claim is for attorney's fees and for the damage that he caused to my vehicle that I caught him doing.
Okay, so your claim is for $5,000. You're asserting all of that as attorney's fees, but now you're telling me damage to a vehicle.
That's what started this whole thing. Yes, ma'am.
So you think you're owed money on that? Generally, how much is that?
My deductible was $1,000 and the damage was 700 something.
So you're looking, so you got paid off by an insurance company, but you spent $1,000.
For to have my car fixed. That's my deductible. Yes, ma'am.
Okay, so you were at $1,000 on that.
Yeah, and the 700 something for the damage that he caused.
Well, but if your insurance paid for that, no, they didn't pay because your deductible was $1,000. Okay.
Yes. So I would like to have my insurance company have their paperwork too. They're owed $291.
Oh, I see. All right.
And I would like my $1,000 back. And I would like him to pay for my attorneys and all that because I've had to put out a lot of money just to defend myself because he made a false police report against me. He assaulted me.
All right. Well, we'll get into the facts. So now I understand what you're asking for. And we'll see if you have the proof for it. So the damage to the vehicle was about $700 some. And that's the sum total out of your pocket on the damage issue, or
that was paid by the insurance.
It was.
I had to pay my $1,000 deductible.
Okay.
And my car is fixed now.
So you paid $1,000 out of your pocket to get your car fixed.
Yes, and I can prove everything that I'm explaining to you.
Okay. Well, that's where we head next, just so we know what you're talking about. So, tell me the car damage first. Let's go there. That's a little clearer.
Ma'am, I went to our community. It's called Steamboat Island store. It's an Indian like cigarette. Get cheap cigarettes there.
Yeah, you got to kind of hone in here. So one day on that day in
on
August
18th, yes, ma'am. I proceeded to go into the store. I parked on the side. I was illegally parked, ma'am. There's a handicap spot there. And I did not want to park in the handicap spot. There's also a restaurant and another gas station there. I was illegally parked.
And how did Mr. Welch, why is he owe you $1,000 for car damage?
Because when I came out of the door, nobody was at the cash register. I went in there. I pulled my car up. I locked it. I walked 10 feet into the door. I was in that store maybe 10 seconds, maybe 15. I walk out the exit door, and the first thing I saw was Mr. Welch.
Talk to me and stay seated.
Yes. I was just going to show you.
Don't point at Mr. Welch. I won't allow him to point or do that.
Yes,
you're going to talk to me, and you're going to stay seated.
Yes, ma'am.
All right.
Yes. And when I opened the door with my hand,
Which door?
The door from the store.
The store door. Okay.
Yes, I just got rang out for my cigarettes. And I opened up the door and I'm sorry.
Again, look at me. You're talking to me.
Yes, ma'am. I witnessed Mr. Welcher, who I don't know at all. He had my mirror. I thought he was going to break my mirror off my car.
Okay, which
And I
mirror?
asked him,
Which mirror?
My passenger side mirror.
Passenger side mirror.
Yes, ma'am.
So the way you parked, then, were you near Mr. Welch's vehicle?
No, I was not.
So his vehicle wasn't next to yours?
No, he did park next to me, yes. and he had his door completely opened like this. And I witnessed him go like
Which
that.
door?
His driver's door.
Okay.
He had it completely opened and he was doing that and it was making my whole mirror turn. I thought it was going to fall off. I didn't know it could bend that way.
So on your passenger side mirror, he's describe again. He's seated in his vehicle, standing. What is he doing?
He was seated in his vehicle, and he had his arm extended and his door completely open, and he was doing this to my mirror.
It is.
And I saw him with my own eyes, and I said, "Whoa, whoa, whoa, sir! Please stop!
Okay.
You're vandalizing my car." And he got so mad at me.
So what was the damage to the mirror? Tell me about that.
All they did. That car is very expensive. It's a special order car.
What kind of car?
It's a super stock red-eye Hellcat.
Okay, I guess I don't know what that is, but it's got a
It's a
passenger side.
$135,000 car. It's special order. I had to wait 9.5. All my cars I had the special order.
So what was the damage?
He took my paint, my clear coat, everything right off my mirror, and it caused a big scrape, which I have pictures of.
Okay. All right. And okay. And so you attribute that to Mr. Welch, and you said you didn't know him from before. How do you know it's Mr.
I saw him do it with my own eyes. That's why I asked him. I needed his information for his insurance.
Okay.
And he almost knocked me off my feet and he assaulted me.
And in what way? In what way? So now we're getting into an
ma'am,
assault.
I'll call it the sumo wrestler. He hit me with his tummy and it almost sent me, I was up against the building. That's why I'm not in the camera. And the security footage
Let
of the
me
camera.
understand. Let me step you back. So he's seated in his car. His driver's door is wide open.
Mm-hmm.
His
Doing
you're
that on my
saying his
mirror.
left hand is on your rear view passenger side
So his hand is
mirror.
on his door and his door is hitting my mirror.
Oh, okay.
Yes, he's
The
running
door is
his
hitting
door
the mirror.
into my mirror, making it trying to break off.
Okay, door in a mirror. And then how did you get close enough to him?
My car was parked right there.
Yeah.
In front of the door, in front of all the cameras at the store. And what bothers me is
Did you come back and around behind your vehicle and then up to Mr. Well?
no, I came right out that door. I asked him for his information. He assaulted
But
me.
his driver's door is open. How did you, and it's banging into yours, so there wouldn't be enough space for you to walk through there. Trying to understand how you got close enough to him to get.
I got in my car. He wouldn't give me any information.
So you got into your
I got
driver's.
into my car.
Okay.
I locked it. I grabbed my phone and I took a picture of his license plate. And
So
the
how
damage.
did you get close to him though? Help me understand what you
Oh,
did.
very simple, because he closed his
Look
door.
at me.
Oh,
You're talking to
yes,
me.
Yes, ma'am. He closed his door. And next thing I know, he's back at me again, standing right over me. And
Closes the driver's door and presumably he's outside of his vehicle.
yes.
Okay.
And he told
then-
me, and he yelled at me something about how I parked and I shouldn't park something. I don't know. I didn't catch all he said. And I didn't care because he's not the police. I was illegally parked. I'll take a ticket.
Then
for it.
what did you do next? Once he
I
closes
asked
the
him for his
driver's door.
information. He didn't. He refused.
Well, where did you go? That's what I'm trying to figure
I
out.
went
Where
right
were
back
you?
to my car. I grabbed my phone and I took a picture of his
Where
license
did you go
plate.
though? Was this the driver's door that you entered?
No, I went all the way around into my car, all the way around
How
to the back
though?
of
What
his
door?
and-
What door did you get into your car?
driver's side.
Okay, so the driver's side door, you open up
Driver's
the
side's
door.
over here, passenger side's over here.
Right, so
His
it's the
driver's side's
other
right next to
side.
my passenger side.
Yeah.
He
so
pulled
it's
into the
other
handicap
side.
spot. He doesn't even have
I'm
a
trying
back.
to clarify. So you open your driver's door, you get in, you get your phone.
And I walked around out of my car to the back of both me and his vehicles.
Okay.
And I took a picture of his license plate.
Okay.
And then he was already at the front by the door that I had come out of, by the front of the vehicles, his vehicle. And he assaulted me again.
Well, the first time I'm still trying to figure out how that worked.
When
So
I asked him
where
for,
were you when you were?
the very first time I asked him for his information was when I saw him with my own two eyeballs damaging my vehicle.
You're not
And
helping me. What
I
I'm
was in-
trying to do is you say that you come out of the store. Where was it that you say that you were assaulted?
Right there in front of that door, in front of my car.
In front of your car door?
That's correct.
Driver's car door?
No, the front of my car.
Passenger car door?
Not
No.
the car doors, the front of
The
my
front?
car.
Oh, so
Yes.
in front of the grill or whatever.
Yes,
the truck. All right.
absolutely.
So you're asserting Mr. Welch walked up
Yes,
to
he
the
did.
front of your vehicle. All right.
Yes. And if
All
I had,
right.
if I had the whole tape, it would really collaborate everything that I told my attorneys. That's why I hired attorneys.
So, all right. And so then that happens. And then what did you do? You went to your driver's door?
That's when I took my pictures after he assaulted me, and I told him, please don't assault me, dude. Just give me your information, sir.
So then you went around, took a picture of
Took the
his
pictures.
vehicle license
After
plate.
I got
and
done,
then
I
what?
put my phone back in the car.
So you went
and
back around to your driver's
Yep.
side door.
And then
Slow down. You went back around to your driver's side door, opened the door, put your phone back in there, closed your driver's door. And then where did you go?
back to the front of, the front of my car, the front of his. He was
Okay.
standing right there.
All right.
And he did the belly thing on me again, like trying to run me over like a big sumo guy.
Okay.
And the first time he did that, I weigh 130 pounds, man. The guy almost sent me
So
flying.
what damage did you have from that? What do you
I didn't
claim?
have no damage,
Okay, well then,
but
all right. So what proof then? Let's step back to the car. What proof do you have that you are out $1,000?
just my deductible.
What proof do you have other than what you're saying?
Oh, honey, I have all paperwork, Your Honor.
All right. Well, what would you like me to see? It's your case. You have to
I would
prove
like
it.
you to see anything that you're
I'm
willing.
not going to rifle through your papers. You look through that and tell me what you think is proof that you're owed $1,000.
This is all I feel I'm owed.
Okay,
right
go
here.
through your papers, figure out what it is, and then we'll come get it.
Okay, it's
So,
right here. I've
all of
already done
that?
that.
Okay, so why don't you come on over here and hand that all to me, and then you'll walk me through it.
Okay,
So come
now
on
I can
over.
approach it now.
Come on up, and then you'll have a seat. Come on up. Hand that to me. Have a seat. And then you're going to tell me what of this is important.
Okay.
What shows that you're owed $1,000 from Mr. Welch? Got all sorts of things.
Yeah, I apologize. I'm not a good,
So I got Capital Collision Inc.
yeah,
They
that's,
say, and where did this come? All right, owner, you, Haggerty Insurance. This is from October of 25. This is alleged to have occurred August of 25. The 2022 Dodge Hellcat. All right, claim number, check. So you got a check for $291, total balance 1291. They received Capital Collision, received the $291. So who paid the $1,000?
I did.
Okay.
There's a piece of paper and they're showing that I paid for the deductible and the summons of service people.
Okay, whoops. There's a piece of paper that, do you have a bank statement or a check or something?
To show.
That you paid or a credit card? How'd you
Yeah, it
pay
should
it?
be on my credit card statement right there.
Your credit card
Yeah,
statement.
it should be right there with all that stuff.
I got Cabela's. I've got.
It's on that
receipt.
Cabela's.
That's your credit card. Okay. All
I
right.
should have
Oh, I see. All
a
right.
service for $90 and $1,000 deductible or something like that on there.
Okay. Capital Collision, $1,000, November 26th. And so you're asserting that this reverts back to the August event.
Oh, yes, ma'am. Yes.
Right.
I didn't want to drive my car. I didn't even know that he had filed a police report on me until.
Slow down. I'm not asking you any questions. I don't want to get off course here. So I've got something from Capital Collision that says you paid him $1,000. They're owed $1,000. Excuse me. Your credit card statement says in November, about a month later. Yeah. You sent $1,000 to Capital Collision. No, this is your bank statement. Balance.
I have my credit card if you'd like to see my credit card.
So there's also an Enki Detweiler on this. Is it a shared account?
Yes, she has a Cabela's card and so do I.
Okay, and it's one card, one account that you're sharing. Is that why you're both on
something
it?
like that? Yeah, I don't know the exact.
Okay, Todd Rivera transactions. All right, so got that. So you sent $1,000 to Capital Collision. I know that much. And that was all right. And then I got your UPS store. Let's not.
I think that UPS is for copies that I had to make for the summons of service people.
All right, so I've got these receipts to Enki Detweiler for $2,000.
That's one of my attorney receipts there.
Okay.
For the
all right.
criminal case. The criminal case I shouldn't have any of the criminal stuff in there, ma'am. It's a separate thing. I apologize if that's in there.
Okay, so, all right. And then what I got here is you think you're owed $5,000 or you from Mr. Welch. Where did you, so I take it, there's sound law here. I see $4,000 worth of receipts. Are these receipts about attorneys?
Yeah, there's another one somewhere, Your Honor. I can't locate that. I'm not worried about it.
So maybe 4,000 you have proof of.
Yeah,
maybe.
it was 5,000 for the attorney,
Okay.
but
So it says from Todd Rivera, Enki Detweiler, $2,000 by English and sound law. And so this is for what?
That is for my attorneys for my assault, fourth degree.
For the charge against you.
Yes.
Let me see. All right. And this receipt is attached to your legal services and fee amount. Let me review this. Flat fee of 4,000. So that's what these two receipts are, is the 4,000 that's indicated in the contract that you've signed with Sound Legal.
Yes, ma'am.
And so one says from Enki Detweiler, but not you. Did you pay the $2,000?
We were both there.
You're the plaintiff. So what did you pay? 2,000?
I paid the first $2,000. The second one, she gave him a check or something.
Okay.
That's why that receipt's in her name.
All right. So you have proof that you paid $2,000. Okay. To Sound Legal. And that was to hire this person for, let me see, scope. Trial, filing a pretrial motions appeal and elector. Okay, so this is all about the criminal case.
Yeah.
All right.
And
Gotcha.
it would be more.
And so you're owed that because you feel that you were falsely accused and that the prosecutor shouldn't have filed charges against you.
No, ma'am, I'm not saying that.
Okay.
I did do to Mr. Welch what he did to me. And I asked him.
Why would he owe you legal fees for the criminal case? Help me understand that then.
Well, I feel if it wasn't for him false reporting me and calling the cops on me after I left.
So you do assert that he falsely reported.
Absolutely.
That
that
you assaulted.
He says I assaulted him. He says all this stuff is on me, and he apparently didn't do any wrong, and that's wrong. That's why I had to go get attorneys and stuff.
Okay.
Because I didn't
for
do
the
anything
criminal
wrong.
case. All right, because you got charged by the prosecuting attorney. All right.
Yes, and that will be
Okay.
dismissed here come March 10th.
And then you got, all right. And then the UPS, I take it the UPS store is, what's that about?
That was copies to give to the serving company.
Okay, so to get service on
Mr. Welch.
tell
Yes,
Mr.
ma'am.
Welch about today.
Yes, ma'am.
Okay. And then, all right, I understand that. And then there's kind of a list of things on a small notebook.
Yeah, I wrote that last night, right before I went to bed, just trying to get as much documentation for you as I can today.
Okay. All right. So
I apologize about the penmanship there.
no, it's pretty good. All right. So Conley Tacone Reserve Consultation 250. What was that about?
That was, I don't know if that piece of paper is up there in that envelope. I think it is. That was to get, may I come up?
You have something
ma'am?
else there you want me? There's nothing else in the envelope. I've
There's
already
a,
gone through everything.
there's a thing from the Messina Tacoma attorney that, here it is right here.
Okay. Why don't you hand that up too, if that's something you
I'm
think I
sorry,
should
Your
look
Honor.
at?
I should have given you this with that other
It's
stuff.
okay. Just hand it up now and have a seat. We'll talk all about it.
Yes, ma'am. I had to go and pay that guy for a consultation fee, if that's
So
what
this
they.
is the assessor's document.
Yes,
I'm looking.
I
at
got
this.
that assessor's thing
Yeah.
printed by the attorney that Taconi, whatever the name is on there. That's how I was able to get the information to know about civil court and
So why
to file.
$250? Did you pay $250 to Conley Tacon in Reserve?
Jan did. She wrote a check to him. Yes, ma'am.
So you didn't.
Well, she did then.
Okay, but that's not
Well,
who's
that's fine.
filing this
That-
lawsuit. All right, and so this is simply because so you could figure out how to serve Mr. Welch.
Absolutely, to try to find out how I could go about doing the right thing, because I had everything filed against me behind my back. I didn't realize, like I said, I didn't find out till 2 days after. And then I'm already an ex-convict, ma'am, so I was really scared to drive my car.
Okay.
You know, I don't
Slow
want to
down. I haven't asked you a question, so I'm trying to map out here. So far, what I've got, you're talking about is $2,000 in attorney's fees. I'm not considering like service of notice or anything or filing fees. I'm just trying to get to the principle here. And $1,000 in damage to the vehicle. So it's looking like $3,000 potentially. All right, that you're out. Is there anything else that I'm missing? Not filing fee, not
I'm
service
just
fees.
grateful that you're here to hear the case. That means a lot to me. Don't worry about the money. I just want my justice for my car and me.
All right. There we go. So, all right, I'm going to hand this all back to you so you can review that. Yeah, come on. Make sure, why don't you sit down and just silently kind of go through it, have a seat, make sure that everything you wanted me to know from that, I know. So just take a seat, review it all, and then look up and tell me if there's anything else, all right?
So Judge Wilcox?
Yep, Marnie?
If I may.
Sure.
My parties may want to request a continuance, so I brought them back into the courtroom.
Okay.
There are
And
some.
who?
So this is 39391.
So Danielle. Flavius. Okay.
And yeah.
Okay. So I'm just going to take that up real quick. You look at things, Mr. Rivera, but I'll come back to you. I'm just going to jump to 39391. So Ms. Flavius and Mr. Johnson, I have you both, Ms. Johnson, unmute. All right. So Ms. Flavius, Mr. Johnson, need some more time today. Set a new court date. Is that what I'm hearing, Ms. Flavius?
That's correct.
Okay. Mr. Johnson, any issue there?
Kind of. She has a 10 o'clock appointment that she has to get to, and I've set aside all day to deal with this.
Well, okay. And I know a lot of people don't realize that they're going to spend the morning with us, maybe longer if we don't get to them because we kind of overbook like the airlines. So I'm going to grant you their continuous, Ms. Flavius, and realize that the next hearing, expect to spend at least the whole morning with us.
Absolutely, Your Honor.
It doesn't prevent you from continuing to talk to each other, to continue to use dispute resolution center services, because Ms. Flavius, part of your filing fee already went to pay for dispute resolution centers, so you paid for them. But we're going to set that court date, and then let's see what.
It'd be April 17th.
All right, we'll be back April 17th. Ms. Flavius, any problem with that date? Mr. Johnson, any problem with that date? Look at your phones if you need to.
That's perfect for me.
Yeah, I think that'll work.
Okay, so April 17th, 8:30. Expect to spend the morning at least. And nobody needs to serve anybody notice anymore. If there's any other information that either Mr. Johnson or Ms. Flavius think you need to file with the court, get it into the court no later than April 10, the week before, so the court can review it and it can be useful. Otherwise, if it's after that, court may not look at it. So we'll see you on April 17th at 8:30.
Thank you.
Thank you.
Thanks so long.
Thank you, Your Honor.
Thanks, Marnie.
Thank you.
All right, back to Mr. Rivera. I had a little time to re-review all of your information that you file. Anything else?
No, ma'am, the only question I would have about that would be the money for my insurance company, the $291 that they had to pay out. I'd like for them to be compensated.
They would have to file their own lawsuit. Yeah, you spend out $1,000. Okay. All right. So I'm not going to turn to Mr. Welch. There's a basic thing called a prima facie case. In criminal cases, there's a basic level that has to be proved for a case to go forward. All I see from what you've shown, I'm also looking at all the exhibits that were filed by Mr. Welch, all the information filed by Mr. Welch. Now, the issue is car damage. The issue is hiring an attorney for consultation. I don't have sufficient evidence. So I'm dismissing your lawsuit against Mr. Welch. You've shown that you paid an insurance company $1,000. I have no other information. Consulting with attorneys, there is no basis that you've shown that this is for some unlawful or legal theory. And then you have to show a preponderance of the evidence, and you haven't even shown that. So that means that the claim is dismissed and the case is done. You have to meet that level before we even have to go to the other side to hear anything.
Okay.
So that's it today. So how about Mr. Rivera, you can be on your way. We'll get you a copy of this order, and then you can be on your way. Mr. Welch, stay where you are.
Thank you so much. All right. I appreciate your time.
You can just hand it to me. Mr. Rivera, why don't you come on over here, and I'll give you a copy. That's for you. And then you can be on your way.
No more civil.
Not from this court, it's dismissed.
All right.
Right.
Thank you so
So
much,
you can be on your way. Thanks. And then Mr. Welch, you can, so you don't have to bump into folks here in the parking lot. Feel free to stay in here or stay by security or make your decision how you want, when you want to leave. All right.
I have a copy for it.
Oh, yeah, of course. I'm sorry, Mr. Welch, can you do the walking? And it's a copy
May
for
I
you.
make a statement?
No, because no one's here. Best not to.
All right.
All right. Okay. So, but you can, maybe a good idea is to wait a little bit, either in here or out there with security, and make sure that you can safely make it to your car. You're welcome. All right.
Well, that's how the cookie crumbles, ladies and gentlemen. Yeah. The little puppy was just barking her head off. Oh, the camera was close. Ladies and gentlemen, we do not have CCTV footage of the sumo, the alleged sumo wrestling move in action at the hard, destructive Hellcat situation, but we have all the descriptive beauty of crazy plaintiff, small claims matter, and Olympia, Washington. Man, ain't Planet Washington fun. So we had at least one confirmed Sov citizen. The guy before him, I admittedly, not much of it. He wasn't a Sov-Cit. He just had some, I don't know, crazy ideas. I don't know. Some of you felt that he had arguments. Some of you probably felt kind of like I did, that he was just blowing smoke, making excuses, kind of like these guys do a lot of the time. Oh, but I'm telling you, the one that really got me was the guy who stole the prosthetic leg. You just gotta ask yourself, why does something like that even happen? It's insane. And then the guy who thought he was going to explain away the girl he just knew from high school because, you know, he was a star athlete and he was very popular and everybody liked him. So he was just trying to bring peace by firing the gun in the air during the robbery. So he definitely deserved the 5 years he's going to enjoy. Ladies and gentlemen, thank you so much for hanging out with me today. It was an interesting set of cases. I hope you thought it was as interesting as I did. Keep your eye out for other releases and other live streams. It's Super Bowl weekend. I hope your team wins. And if they don't, I hope you find some good court to watch in the meantime. I will be here. Law Nerds Unite will be here. Hutch will be here with all of his channels at, you know, what are the Sovereign Citizen Encounters? Mike, everybody else. Colin, what can I say? But I, most assuredly, will have more content for you. So keep an eye out. Because I have stuff that I know needs to be released and I just haven't found time to do it yet. That is the struggle of your humble Lone Wolf Usul. And I will be here every single day trying to bring you some more content just like this. So with the puppy on the couch, me in the chair, I'll see you all out there. But for now, I'm going to say thank you for hanging out with me. I'm your humble Lone Wolf Usul for the third time, or fourth, or fifth, what the heck ever. I am out. I'm going to say this once and only once, and I'm going to mean it, and whatever the repercussions are, let them lie where they are. Go Seahawks.